Hello. On behalf of WR Immigration, welcome to our discussion today, Immigration Planning, Preparing for a Global Recession. We're not economists, we're immigration attorneys, so we won't be making any predictions on the state of the economy, but rather we'll be discussing what to consider for your company's global immigration program in light of the recent headlines regarding the state of the economy. I'm Laura Bloniarz, Senior Associate with WR Immigration in our LA office, and I specialize in U.S. corporate immigration.
Hello, everyone. I'm Audrey Lustgarten. I'm the managing partner of WR Global, and I specialize in global immigration, which is really everything outside of the U.S. as far as WR is concerned. Back to you, Laura.
So before we begin, a little bit about the firm. A little bit about WR. We are an award-winning and top-rated immigration law firm that provides strategic client-centered services. We leverage our attorney talent in combination with our innovative technology to deliver high value for our clients. Speaking of technology, Rapid is award-winning too. It is centralized cloud-based technology. It's powered by Salesforce and driven by artificial intelligence. If you'd like to learn more about WR Immigration or Rapid, please reach out to the WR Immigration team. Finally, before we dive into our discussion, our last bit of housekeeping. Please note that this presentation is not legal advice. It is for educational purposes only. If you'd like legal advice, please reach out to the WR Immigration team to set up a consultation. And with that.
Great. Thanks so much, Laura. So this is a little roadmap of what we're going to cover today. It's a stressful time, as Laura mentioned, in the economy in many countries around the world, and layoffs are not something that anyone wants to be dealing with. By definition, letting go of people you otherwise would not, who are potentially valued contributors to the company, that's not something that you want to do. You likely want to take care of them as much as you can, given economic constraints. A lot of considerations go into layoffs, and it can be all too easy to forget the immigration piece or leave it to the very end. But it's really crucially important not to do that. That you're here today listening is a good sign. So we are going to talk through how an employer can support their foreign national employees in the wake of layoffs, what happens when employment is terminated for a foreign national employee, and then what happens when, to the foreign national employees who are not let go, who are left behind. Are there impacts to them, either in the present time or even in the future? A big theme is that we want to be forward-looking and planning as much as we possibly can. So next slide. Regardless of what it's called, if you're responding to potential market signals, or even if it's just a business life cycle, you'll want to know how to prepare your immigration program before these unfortunate employment changes occur. Different terminology is used globally, downsizing, rightsizing, streamlining, layoff, redundancies, reduction in force, all of those things, but it really boils down to the same idea. It's a non-voluntary termination of employment at your company, and it's going to have an impact on your company's immigration program. We're seeing in the news as recent as I think 3 or 4 weeks ago that companies like Amazon, Twitter, Netflix, Peloton, kind of some of the star companies that have come through the challenges of the pandemic over the last several years are now in the position of having to lay off thousands of employees. I think the statistic was more than 73,000 U.S. tech workers were laid off, just as of a couple of weeks ago. WR is here to help and support companies in this difficult time. And a big thing that my department is doing right now is that we're helping companies coping with layoffs by really providing multi-jurisdictional analysis of the layoff impact on a global basis. So not just siloed in one country, but looking really broadly across the board. And this is so important as immigration, the immigration impact of having layoffs differs significantly from one country to another. But it's important that companies, particularly global companies, are taking a kind of coordinated approach and handling their messaging really carefully. And to do that, you need to know what are the impacts going to be, who is going to be affected, who is going to potentially need to leave the country, switch to another visa category, whatever it may be. And really, it's all about how the employer can support the foreign national employees in the wake of layoffs. So back to you to talk about that, Laura.
Yeah. So how can an employer support their foreign national employees in the wake of layoffs? Obviously, as Audrey was saying, termination of employment is always tough, but it's particularly tough for foreign national employees because they're worried about how can they stay in the country. To the greatest extent possible, we recommend proactive communication with employers' immigration counsel to ensure that the legal team is prepared to dedicate sufficient resources timely to support consultations or analysis. Now, the pre-conversation before layoffs may not happen. Sometimes, and many times with my clients, it's after the announcement of termination. But to the greatest extent possible, the proactive partnership with U.S. Immigration Counsel, Global Counsel is important for planning and dedicating resources to analyze the impact for terminated foreign national employees as well as retained foreign national employees, as both experience unique challenges after layoffs. We strongly recommend, to the greatest extent possible, timely consultation. Again, that's going to depend on size and scope of layoffs, but because of these unique challenges the foreign national employees face and tight timelines for terminated foreign national employees, the getting the information and the tailored approach, as every situation is slightly different, and foreign national employees have different fact patterns that do require specific consultative advice to be in the best position possible in these very delicate and challenging situations. So we're going to talk about impacted foreign national employees first when the employment relationship has terminated. We're going to look at it from the employer side, what the employer needs to do and what obligations they have for compliance. And then we're also going to look at it from the foreign national employee side, what compliance and timeline actions they have in the wake of termination of employment. So to start, as an employer of foreign national employees, it's critical to follow the required obligations for terminating foreign national employees. Specifically, the H-1B workers have very specific exit requirements. The employer has the following obligations when terminating an H-1B employer. First, they have to provide notice of termination to the employee in writing. Sounds obvious, but you'd be surprised where this is missed with employers. So not only is the verbal notice given, but also something in written handed over to the employee. So you want to make sure that's part of the process, if it isn't already. Secondly, in partnership with probably your U.S. Immigration Counsel, you're working to notify USCIS, U.S. Citizen Immigration Services, of the H-1B workers' termination. So another statement in writing handed over to this government agency to ensure you've checked this box completely. And finally, this one can also get missed, the offer of terminated employee to the offer to the terminated employee, the cost of reasonable transportation to that H-1B worker's home country or country of last residence abroad. You'll want to make sure in the process, whoever's managing this practice, that the documentation has been reviewed and standardized so that it's given out consistently and timely in the wake of termination. You'll want to make sure all the documents are kept. So if you're emailing the document to the terminated foreign national, that you're saving those correspondence and likely giving the H-1B worker a deadline to respond. If these three things are not completed, the government does not consider a proper termination of employment, and that would leave the employer on the hook for wage and hour liability. For those of us that are in the weeds and filing H-1B petitions frequently, you'll know this comes from the labor condition application. This is the filing with the Department of Labor, and that's where this wage and hour liability attaches. So something to be carefully considering in your process to make sure, again, it's timely and consistently done, especially in the wake of layoffs.
Great. And, as I mentioned before, the impact of layoffs or any form of involuntary termination is going to really differ from one country to the next. And that's why it's so important to take kind of a global view and make sure that you're doing your due diligence in each country where you've got employees who will be, potentially impacted or will be impacted. I've got a few examples here. Obviously, there are a lot more countries out there. We don't have the time and space to go through an exhaustive list of everywhere. We're currently assisting clients with layoff impact analysis. But some of the, jurisdictions that are very popular with our clients, I've included here, and also tried to get a bit of a variety in terms of how they deal with layoffs and what the considerations are for employers in those jurisdictions who will be having or have had layoffs. As Laura mentioned, unfortunately, sometimes we don't find out until after the fact. The layoffs have already been scheduled or have already been completed, and then we're scrambling to make sure that the employer is completing the required notifications as soon as possible. Obviously, it's much better if it can be planned out in advance so that none of the steps are missed, particularly when you're dealing with having to give notice to government agencies in multiple countries around the world. So one I've got on here is Australia. Australia has a pretty sophisticated immigration system, not completely unlike the United States. A lot of compliance requirements, a lot of notification requirements for different things that occur during an immigration life cycle. And not surprisingly, Australia requires employers to notify the government within, they give 28 days from the last day of employment. The employer has to notify that there has been an involuntary termination of an employee who has been sponsored. And when I'm talking about the notice requirements, I am, full disclaimer, I am talking about the most common temporary visa status in Australia, which is the subclass, the 486. So there are a lot, similar to the US, there are a lot of different types of visas in Australia. Some are employer sponsored and some are not. Obviously, for the purpose of this talk, we're focusing on those that are employer sponsored and would require action and notification in the case of layoff. In addition, Australia requires that employers provide return transportation to the terminated employee for them to travel to their home country, their country of passport. And that also includes family members of the sponsored foreign national employee or ex-employee in this case. So the whole family needs to be provided with economy class transportation back home. One little twist here is that the employer is only obligated to provide this return transportation to the home country if the employee requests it. And then so the employee has to proactively ask for this, ideally in writing, so that there's evidence of it. We strongly recommend keeping records of this sort of thing. So if a request is made, keep a record of it. And the employer has 30 days from the date of that request to provide the return transportation, most commonly, I think, in the form of economy class airfare. This does not encompass return transportation for household goods or any sort of moving assistance. It's really just for the people, the foreign national employee and their immediate family members that came over together on that sponsorship. It is, in terms of employer considerations, it is important to flag that Australia does have the concept where layoffs can make it more difficult for an employer to subsequently hire foreign nationals in the same occupational classification where there have been layoffs. So that's something to keep in mind. Obviously, the economy can be a bit of a roller coaster. One day you're looking at layoffs, the next day you're looking at hiring again. Obviously, we all hope that will be the case and that all the economies that are suffering now will rebound. So just keeping that in the back of mind that can impact going forward. It can be overcome with reasonable explanations. So it's not an absolute bar, but something to keep in mind. Switching to Canada, which is one of the friendlier jurisdictions in terms of immigration rules, honestly, on a global basis, Canada makes it really easy on employers. They don't want to add to your burden that you're already going through by having to do layoffs. And so they do not require notification for many common work permit types. For example, if you have an employee that holds an intercompany transfer work permit or a CUSMA, some still call it NAFTA-based work permit, similar, it's basically the flip side of the USTN, you do not have to notify of the termination. However, if you've sponsored a foreign national for a labor market impact assessment based work permit, then there are notification requirements to keep in mind. So it's important. And obviously we do this when we're going through an analysis, a multi-jurisdiction analysis of layoff impacts, who is the employee that will be laid off? What is their citizenship? What type of permit do they hold? Looking through the details to make sure that you're catching any, required actions on behalf of the company. And then last but not least, the UK is another area where we have seen a lot of clients go over the past couple of years. And they are more along the lines of Australia and the United States in that employers are required to notify the UK Home Office, the government, and it's actually within 10 days of the last day of employment. So this is a jurisdiction that it's always very concerning to us if we don't find out until after the fact if layoffs have occurred. You've got a very narrow time frame to file this notification. It is done through the sponsor management system portal, so electronically, which is nice. You don't have to worry about getting something postmarked, but again, a very short turnaround. So just crucial in the UK to keep track of this, to plan in advance, and to file that notification in a timely manner. If you do not file a timely notification, it can impact your ability to sponsor foreign nationals in the future. It can result in a downgrade of your sponsor license or revocation of it in serious cases. So keeping really close track of that is important. And then this is not an immigration consideration, but I always feel obligated when I'm speaking about global to a US audience, or primarily a US audience, to flag, please be mindful of employment law. This is outside the scope of WR's practice, but employment law considerations can be very stringent. It is not generally employment at will as it is in the US. So obviously that will be an important consideration as you are contemplating layoffs.
Perfect. So we discussed from the employer perspective, the compliance requirements, US and global, and now we're turning to what happens when employment is terminated for the foreign national employee in the US. So from their perspective, what are their considerations and what are their stressors? Well, many visa holders do benefit from a grace period, which means the foreign national may remain lawfully in the United States for a specified number of days. The visa classifications here are some of the most common ones in the US, and they have a 60-day grace period, which means that they have 60 days in which to file a extension of their status or change of status, and the application must be lodged within the 60 days in order to be validly filed for that extension or validly filed for the change of status, whatever the situation may be and what they qualify for. To draw that out, if a foreign national employee is terminated today, let's say that's an H-1B worker, so they're terminated today on Tuesday, December 13th, their grace period would expire then on February 10th. So Assuming that an H-1B transfer petition can be filed within 2 weeks, and we all know, for those of us that work closely in this area, 2 weeks is quite an expedited time frame for all parties to lodge the H-1B petition. But assuming that happens, that H-1B worker has 46 days, or just about a month and a half, to complete job applications, to complete interviews, to receive and accept an offer. That's an extraordinarily tight time frame for that H-1B worker to get that all aligned for a timely filed H-1B transfer, or also known as change of employer petition. So initially the 60 days seems like, oh, that's sufficient time, but I know I've read stories in the papers that are sort of explaining just how stressful that time frame can be. So in the case where the foreign national employee is unable to find a job, for new company sponsorship, they're left with very limited options. One option is to depart the U.S. before the end of the grace period. Alternatively, before the grace period is over, the foreign national employee that's been terminated may change status. Now, if they're doing this on their own, it's, again, pretty limited in what status they can change. Before considering this, we would recommend that foreign national reach out to counsel, because there's going to be a lot of considerations on changing status. You'll want to understand the impact and timeline for filing a change of status. And also, there are extremely significant consequences to remaining in the U.S. without timely filing an application. So if you're staying here outside the grace period as a foreign national employer, there are significant consequences to that, meaning loss of benefits in the future, or even dramatically immigration bars to the U.S. So if you're finding yourself in this situation, the consultation with a immigration attorney is key, so that you are not putting yourself in more challenges as a foreign national employee during this period. So that's the foreign nationals sort of work authorization or non-immigrant visa considerations. But then there is the long-term considerations that also come up for a terminated foreign national employee. And that is for their long-term green card sponsorship, or their ability to obtain legal permanent residence in the U.S. And those are broken down here. So for a PERM process, a foreign national who may have been sponsored through their employer through the labor market test with the Department of Labor would go through something called PERM. Now, if the terminated foreign national was being processed through PERM from their employer, it's fair to say that the best practice here is that that employer is going to stop processing that application. So as we all know, folks that have been working in this space, the PERM process is extraordinarily long these days with delays in Department of Labor. So if you're a terminated foreign national who's part of this process or in this process, it is clear that the employer would stop processing that application regardless of what milestone you're at. And even if your application had been filed, if the PERM application had been lodged with the Department of Labor, again, we recommend to our clients, corporate clients that is, to even withdraw that filed PERM application. The reason being is a few. First, after a layoff, the employer may see higher rates of audits for filed PERM applications, and they would not want to respond to an audit for a terminated employee, but would be required if that audit was called before it's withdrawn. So we recommend our corporate clients to withdraw those PERM applications before subject to audit and the burden of responding. The second is that even if the PERM application had been approved for a terminated employee, that PERM certification would not be moving to the next stage with it, which is that immigrant petition form I-140. So pretty disappointing, but that would be what to expect as a foreign national employee, and the best practice for the employer would be to stop processing PERM or withdraw even if filed. For those that might be in the process of the immigrant petition or form I-140, similar analysis. If you're in a legal workup stage, employer is not going to complete submission of the immigrant petition. If your I-140 or employer has filed your immigrant petition and it remains pending, we see different practices. I've seen some corporate clients, because of their policies, they leave it pending. But if RFE'd, they would not respond and withdraw at the point of RFE. Some clients would withdraw with a pending I-140 because they don't want the burden of responding. Again, this is probably going to depend on size or scope, what the employer is going to do, but suffice it to say, as a terminated foreign national employee, unless you have an approved I-140 petition, you're at risk of that process unraveling and not being able to be leveraged by a new employer. Now, if you do have an approved I-140 and with the employer, as a foreign national employer, you're able to retain that priority date with your new sponsorship through a new employer and retain that priority date, your spot in line for your green card. Now, last but not least, in the case of a pending adjustment of status or Form I-485, in certain circumstances, the terminated foreign national employee may continue processing their I-485 adjustment of status application with the new employer. These situations are rare and all the following must be true. So the employee's I-485 adjustment of status application has been pending for more than 180 days. So that means it had to have been filed more than 180 days prior to the termination date. And the new employment in the US, so the new employer is with a similar occupation as the originally filed PERM or underlying PERM or I-140 application. And USCIS is notified of the change in employment using the Supplement J Form I-485. If all three things are true, then the terminated foreign national employee's pending adjustment of status remains viable in the wake of the termination. And now back to Audrey. You're on mute.
Thank you. Thanks so much, Laura. A lot to think about there. A lot of stress for terminated foreign national employees. Shifting back to the global perspective again. There's a lot of stress globally as well. It's not just the United States where foreign nationals who have been terminated have to worry about being able to stay in the country where they and often their families have been living for quite some time. So looking again at three of the most popular jurisdictions here, Australia is quite similar in some ways, again, to the United States. The terminated foreign national has a discretionary period of 60 days to find another employer or to switch into another visa status, or obviously they're always free to depart Australia. If they're not able to do that, they would need to depart within the 60-day time frame. Australia does have a number of different visa options that it may be possible in some circumstances for individuals to switch into on their own without an employer sponsor, but it is, like the US system, quite complex. So likely makes sense for them to have a consultation with an immigration attorney to sort out what, if any, independent options are available to them to be able to legally stay living in Australia while they're trying to figure out the next steps. It's really important to note that even if they're terminated and their visa is, still on the face of it valid for quite some time, that does not mean that they can work for a new employer. It is necessary for, if they are fortunate enough to find a new employer who's willing to sponsor them for a work visa, that new employer apply seek a work visa application for them, and that be approved before they actually begin working for the new employer. Working without following that process, or anything else that is prohibited on the terms of their visa, such as working for themselves, as an independent consultant, anything like that is considered to be violating the terms of their visa, and it would actually be voided, as of the time when that violation occurred, rather than having that 60-day grace period to sort out options. So definitely a serious situation for foreign nationals to be in if they are laid off in Australia. Canada is a bit of a better jurisdiction to find yourself in if you are a foreign national employee who has been laid off. They allow you to remain until the expiration of your current immigration status. So even if you are laid off, December 13th, 2022, and you have a work permit that's valid until, sometime in 2023, 2024, you are able to legally remain in Canada up until that expiration date. It is very important. We strongly advise against traveling during that period. So if a foreign national is laid off and stops working, and has a work permit that's valid on the face of the permit, that's fine for staying in Canada. Traveling internationally is definitely a big risk because the immigration officer at the port of entry is going to have discretion when the foreign national comes back to Canada on whether or not to admit them. And the conditions that led to the granting of their permit are presumably no longer in place if they're not working for that employer. So the officer would be within their discretion to deny entry. And that would obviously be really unfortunate. So we say, stay put in Canada, look for a new job or for another visa category to switch into on an independent basis, but don't travel. Still way better off than if you were in the United States or in Australia, though. And then lastly, looking at the UK, again, we see this 60-day grace period or until the expiry of the current immigration status, whichever is shorter. The little trick here is that the 60-day grace period in the UK doesn't actually start ticking until the Home Office has issued something called a curtailment letter. And that curtailment letter is not issued until after the employer obviously has notified the Home Office of the termination. So you can stretch that out if the employee stops work, today's their last day, the employer waits 10 days to notify. And then sometimes if you're lucky, the caseworkers at the Home Office are overworked and don't get around to sending that lovely curtailment letter out for some time. Sometimes it goes out the next day. Sometimes it takes a few weeks. And it's not until that's actually issued that the 60 days starts ticking. So you can buy a little bit more time there. As Laura has said, 60 days seems like a long time, maybe to you or I sitting here today, but when it's 60 days to find a new job and get a visa application filed or uproot your family and move around the world, that actually isn't a very long time to deal with everything that goes into that. And that's definitely, more true perhaps now than ever with some of the backlogs that we're seeing in immigration case processing. You might find a new employer, file an application, and then wait a good long while before the government actually adjudicates it, which is just yet another source of stress for a foreign national that is already under a lot of pressure. And then just a little reminder, I know I said it under Australia, but it really applies to all of the above. Definitely no working for a new employer without receiving, without applying for a new visa or permit. That is required in the vast, vast majority of jurisdictions. They will not allow you to transfer or just, show up and start working for a new employer without having a, visa or permit that is specific to that employer and authorizes you to carry out work there.
Wow, a lot to consider.
Yes.
So I was mentioning at the beginning of the discussion that retained foreign national employees also face unique challenges in the wake of layoffs. So we're going to talk about maintaining U.S. employment relationship with foreign national employees after layoffs, because in addition to feeling stress of the colleagues that all the employees at the company would feel, they're going to be worried about not only their immediate status changing or needing compliance updates, but they're also going to be worried about how it impacts their timeline for green card and ability to stay in the U.S. So these are things we're going to want to carefully consider and work with Immigration Counsel to strategize and tailor to each retained foreign national employee. The first thing you're going to want to consider immediately in the wake of layoffs at the company is there may be changes to the retained foreign national employees' employment terms. So often layoffs may mean job changes or additional locations or potentially decrease in salary. If any of those things happen, they need to be screened for amendments. This is something that ideally, again, is filed before the changes happen, but in the rush and likely lack of notice with Immigration Counsel, it's going to all kind of happen at one time. But we want to make sure for compliance for not only the foreign national employee, but also the company that these amendments are filed as quickly as possible when notified of the job changes. Most critically, though, in the wake of layoffs, our impact to the company's ability to sponsor through the Department of Labor's PERM program. So if foreign nationals have from the company that are retained already have an approved or pending immigrant petition and there are no changes in their job, location, duties, they're in the clear. But for all the employees that are part of the PERM pipeline, whether they're having legal workup, pending prevailing wage request, even a submitted PERM, are going to face some challenges here. And that's because the employer may be timed out from submitting PERM applications with the Department of Labor for 6 months from the date of termination for same or related occupations in the area of intended employment. So there's substantial risk for employers to submit PERM applications with the Department of Labor after these mass terminations, if not properly screened and properly vetted for notifying and considering laid off U.S. workers, if that's something the company even wants to do in light of large layoffs. So to draw this out a little bit in more detail and to track examples from recent headlines, let's say tech company ABC recently laid off hundreds of software engineers based out of their Silicon Valley headquarters. This clearly impacts tech company ABC's ability to sponsor, retain foreign national employees who are software engineers in Silicon Valley headquarters. The tech company ABC is not likely going to consider and notify all the U.S. software engineer workers that it laid off because the burden would be too high. Again, depending on the size and scope, the ability for them to notify all of these recently laid off U.S. workers who held the position or a related position of software engineer is going to be likely too burdensome to do, not to mention the company likely doesn't have the tolerance to do that in the sort of communications that they had based on the layoffs. So what that's going to do is going to bump out the timeline to support PERM sponsorship for retained foreign national employees who hold the position of software engineer at the Silicon Valley headquarters. And I think this gets further impacted or further significant for foreign national employees who are retained in light of telework. So those of us that file these applications regularly are familiar with telecommuting language triggers a headquarters location. So it makes it even more impactful that even if the foreign national employee that you're retaining is actually in another location, but your PERM program files everything as telecommute, you're making it more difficult. The PERM program is in a really difficult spot to sponsor that foreign national employee, even if they're in a different location. So a lot to consider. And essentially the takeaway here is that layoffs for retained foreign national employees stretches out the timeline for green card sponsorship significantly for these retained foreign national employees. So you want to make sure that that's part of a conversation and consideration in the wake of the layoffs. And that's really like the first point here is that in the wake of terminations, employers going to need to work very closely with immigration counsel to run reports to just understand, who of this retained foreign national population may be facing max out issues. The sponsorship timeline is critical to understand in the wake of layoffs, and counsel and employer are going to want to be meeting with the retained foreign nationals to reset expectations about what that timeline looks like. Conventional wisdom in this area historically has been for an employer to start sponsorship 2 years prior to the max out of the non-immigrant status. So, for example, to break that down, for an H-1B worker who has 6 years of work authorization status, that wisdom said to initiate the green card process when that H-1B worker was in their 4th year to make sure there was enough time to complete all the relevant filing milestones to ensure maintenance of status and continued work authorization for the H-1B worker. Now, as we know, processing times with DOL are exponentially increased, and we should really be considering starting and initiating green card sponsorship at the H-1B worker's 3rd year mark to ensure there's enough time, especially if the company is going through layoffs, because that timeline becomes even further extended. The other thing to consider in these consultations with immigration counsel post layoffs is considering the retained foreign national employees for alternative paths to green card. One example is if you have someone with a PhD in STEM, then they should definitely be screened for an EB-2 national interest waiver as an alternative to PERM. And what this means is that they're not subject to the Department of Labor PERM process and PERM timeouts that we were just discussing. Other alternatives, if available for international employers, would be to consider international rotations. So I've had clients who have headquarters outside the US, and culturally they value international rotations within their career progression. So we strategically build in with their rotational opportunities abroad and place together some really compelling US immigration strategies, because international rotations may lead to even more advantageous green card paths, assuming employers can accommodate this. There's some very strategic paths we can create for green card strategies here in the US. So a lot to consider, and this is a lot all at once, again, because we want to make sure as the employer, you're addressing the terminated foreign national employees' concerns, but at the same time, given these unique challenges for retained foreign national employees, need to be concurrently addressing those because time is of the essence.
Absolutely. And this is also where, the global piece of WR comes in and is able to work kind of hand in hand with the US team, because we can look at that. And if we're taking a global view, okay, the company is going to have layoffs. These are the impacted employees. These are the retained employees. And how can we mitigate the impact, as Laura was saying, on the retained employees if they are impacted negatively from a PERM perspective, from a permanent residence perspective? Can we look at an intercompany transfer work permit for them to go and work in Canada for a year that might open up additional pathways to permanent residence in the future, and kind of analyzing that across multiple jurisdictions to hopefully find a solution that lets companies retain the talent that they need to and are able to despite the tough times, and then preserves that talent, for the future, so that when the economy recovers and things rebound, the company is not left without, the crucial foreign national talent that it really needs to succeed. So, but yes,
thanks.
A lot to think about.
So kind of wrapping up some key takeaways, to reinforce the messaging here is partnering closely with Immigration Council to ensure the dedicated resources are available to timely support impacted foreign national employees. And as Audrey and I were just mentioning it, and it's not just the terminated foreign national employees, it's also the retained foreign national employees, to make sure you're setting up those strategies, because with a global strategy, things take time to put in place, and depending on what lead times you have to maintain work authorization in the US, you might need to immediately action the global piece to get their work authorization in Canada or wherever it might be to align.
Mm-hmm. Absolutely.
Considering all impacts to foreign national employees, we want to make sure the employer is considering all compliance requirements for proper termination, but also looking for the employee's need for compliance and expedited timelines to remain in the U.S. lawfully, as well as considering the overall green card sponsorship timelines for retained foreign national employees.
Yeah,
Audrey, some closing?
Yes, there's lots of takeaways, trying to condense it down a bit here and also not repeat too much. But I would just say that, fortunately, what Laura's been speaking about, the impact on retained employees, is not as big of a concern globally. The US is one of the more difficult jurisdictions. Most other countries are not going to significantly impact the retained employees directly in terms of their ability to get permanent residence or long-term residence in the country. So that's a bit of good news on the global side. Like to highlight the good news where we can. In terms of, other key takeaways, just as I've said before, really encouraging companies to take a global approach, take a holistic approach, look at the whole picture. What are the compliance requirements in the different jurisdictions? They likely are going to differ significantly from one jurisdiction to the other. So you may have much easier time of it, for example, in Canada than you would in the US or the UK. And sometimes taking that holistic approach can also allow us to open up creative solutions, again, to retain that key immigrant talent that you need. I think also, in this process, technology is your friend. You have a lot to keep track of with layoffs, who's being laid off, when, what are the required notifications to the individual, to the government, what else do you have to do? We've got a really wonderful system, as Laura mentioned before, in Rapid, which is our proprietary immigration case management system, where we can track a lot of key metrics and really help to support our clients in keeping track of everything during a stressful time, to make sure that all of the required notifications are taking place. And, we're looking at impacts on retained employees to try to mitigate those wherever it is possible to do so. So I think those would be my takeaways, Laura.
Awesome. We do have some time for questions, and I think, are there any in the Q&A section?
We have some questions. So I see the first question, I think, is for you, Laura. When does the 60-day clock start for H-1B visa holders? Is it the last effective day or the last date on their pay stub?
So I think there's a gray area here. Conservatively, you would read the regulations as the date of termination, the last day worked. But certainly I have successfully applied for transfer petitions when someone has still receiving pay stubs 60 days from the last pay stub. I think this could get really challenging in light of the recent tech layoffs, where they were so publicly announced, where it was very clear when the last day for many of these H-1B workers or non-immigrant visa holders, when their last day was. So I think there could be a trend of RFEs, or, in the worst case scenario, denials if the transfer is filed 60 days after the pay stubs are received, because I know many folks received severance packages that were perhaps 10 to 12, many weeks after the actual date, last date worked. That's all to say that it is a gray area, so there's room for USCIS to interpret it. So if you were most conservatively, you would be considering the 60 days from the date of termination. And I think the critic in me says that because of all these really public announcements, we could see some pushback from USCIS if someone's trying to file a transfer within their sort of severance period.
Makes sense. Good to be conservative, probably, especially if your company is making headline news. We have another question for you, Laura. What are the risks to submitting perm applications after layoffs?
Well, so assuming the perm application was properly vetted, meaning the perm application was for unrelated occupations, meaning not related to the laid off U.S. workers or in different locations, you're going to see, the employer is going to see a higher rate of audit. Because again, especially in light of like public announcements of layoffs and headlines, the Department of Labor officer, it's within their discretion to automatically issue audits in light of layoffs. So certainly you're going to see a higher rate of those audits, like I said, and maybe even denials. So that could be quite challenging. And again, you might think you're in the clear because you're able to submit the perm application, but an audit would, best case scenario, even if it is compliant, may delay the certification of the perm application for 8 to 12 months. So some pretty challenging times ahead, even if compliantly filed.
Definitely not an easy time.
Yeah. This one's for you, Audrey. How can global immigration program managers best coordinate in the wake of layoffs?
Well, I'm going to take this as, in the wake of layoffs, I guess after the fact, potentially they haven't done the advanced planning. I would say the most important thing is, as soon as you realize you should have done the immigration piece of this all, to seek legal counsel, because as, I've spoken about earlier in the presentation, in some countries you have a really short time frame to file required notifications with governments. You might get lucky. You might be in a jurisdiction like Canada with a work permit type that doesn't require it. And then, you'll just have the moment of panic, the consultation, and then happily ever after. But if you're in a jurisdiction like the UK where you've got 10 days, that's a very short period of time, especially when, the global immigration program managers have a lot going on every day. 10 days can fly by. If the worst case scenario, when you realize this should have been done, that time frame has already passed. It's still better, generally speaking, to take action, because then, even if you have notified late, if you have been the one to proactively reach out and notify the government, that's still much better than the government finding out about it when they audit you. And at that point, you say, "Oh gosh, I'm sorry, we didn't let you know about all of these layoffs and all of these changes." So better to be proactive, even if it is late. Obviously, ideally, you would get yourself a time machine and go back in time and plan in advance. And that's one reason that, we are writing on this and we are speaking about it, because we are seeing that layoffs are gaining momentum, and it's so important for the immigration aspect of layoffs to be on companies' radars. And it's so easy to miss it because you have so many other things going on.
Yeah, absolutely. That I've got a question following up. So if in the UK, the company is unable to notify within that 10-day period, and then they notify after, so obviously they're sort of disclosing, "Hey, our fault. We didn't meet the timeline." Are there consequences to that?
Yeah, there definitely can be. Again, I don't think it would be likely for, a single instance. You lay off one person and you forget to notify. It's unlikely that the UK government is going to revoke your sponsor license altogether for that. But it definitely does present a risk. Sponsor licenses can be revoked for failure to timely notify, particularly if there is a pattern of failure to notify. And the failure to notify doesn't necessarily always need to be layoff related. There are a lot of required notifications. The UK loves notifications. They love their online sponsor management system. They want you to tell them every time anything changes. So it could be that the failure to notify of the layoff is the last straw in other failures that have happened. So you don't want that to happen. And
Sure.
Once if a company sponsor license is revoked, is that you would not be able to sponsor foreign workers in the future until you're able to hopefully at some point have that reinstated. But that's difficult to do once there have been a pattern of failure to comply with required notifications.
Okay, that makes sense.
And a follow-up one for you, Laura, here it looks like is the offer of return transportation for the H-1B employees that are terminated. Is that something that companies have to proactively provide, or is it like Australia where you can wait for the employee to ask for it?
So the company must proactively provide. So that's part of the requirement to effectuate a bona fide termination of an H-1B worker. So I think this one is often missed because I don't know, small H-1B programs may not have an administrator for this piece of the program. They may not know that it's part of it or think someone else is handling it, the person that's still the manager that's delivering the news or things like that. But it is a requirement for the company to proactively offer.
Okay. And if they don't, then they could be exposing themselves to wage liability. Is that the result?
Correct. The wage and hour liability under Department of Labor rules. Yeah. And the foreign national that's terminated often doesn't take it because they want to move to a new H-1B employer within the US. So often it's a decline, but there needs to be some documentation that the terminating sponsoring employer has offered it.
That makes sense. So back to keeping good records of what you've done. Not enough to just do the right thing, but you have to document it every step of the way.
Exactly.
That's all I see in terms of questions in the chat, unless anyone else has other questions they have not asked yet.
Don't be shy. And if something comes up later, don't hesitate to reach out to Audrey or I after the program. We're happy to answer questions related to this or set up a consultation with the team.
Absolutely. And also wanted to make sure everyone saw we have another really great webinar coming up with Charlie Oppenheim, who we are so excited he has joined WR. He's going to be speaking on demystifying the immigrant visa backlogs and looking at his crystal ball on Thursday, December 15th at 11 a.m. Pacific. So we've got the QR code there if you want to register. Obviously, it's also available for registration online if you decide to sign up later. But Charlie's wonderful, so I'm sure it'll be a really great discussion.
Yeah, absolutely. I'm excited. I'll be tuning in as well.
Mm-hmm.
And this is our contact information. So if there are any follow-up questions or you want to set up a consultation or a rapid demo, don't hesitate to reach out to myself or Audrey. Thanks for joining us today. We look forward to hearing from you. We'll be sending a recording as well as a copy of the deck, and we welcome your feedback on this presentation.
Absolutely. Thanks so much, everyone, for attending.
Thank you.